Everyone, I'd like to introduce the panel. This is a panel discussion on the intersection between clinical and legal practice. So we have we're going to talk about the intersection between mental health and the legal arena with a single case, a composite yet very specific example with a panel of esteemed mental health professionals. Dr. Kelly Baker has provided divorce services for over 20 years, specializing in parent-child contact issues for the last 13 years. She's been a therapist, parent, and co-parenting coach, guardian ad litem, custody evaluator, and conducted parental alienation assessments and managed couple reunifications. Dr. Michael Bone has been in parental alienation for the better part of 3 decades. He has a national practice working with legal teams and the targeted parent. Dr. Robert Evans is a forensic psychologist with a focus on parental alienation, including allegations of parental rejection, child abuse, sex abuse, and estrangement. He's performed approximately 400 child custody evaluations. Dr. Amy Eichler, I got it right the first time, is an associate professor of psychology on the faculty of the University of Mary Hardin Baylor. She maintains a practice as a clinical psychologist, specializing in high-conflict divorce situations. This presentation is a real-life parental alienation case, avoiding the sins of omission and commission. Floor is yours when your guys are ready.
Well, hello. We're going to be presenting a family situation, and as we go through that, we're going to talk about some of the high points, critical points that we think we need to, as forensic mental health professionals, need to pay attention to and consider some potential hypotheses and issues.
Questions at the
Yeah, and at the end? Or?
I say during.
So any questions, any comments, feel free to raise your hand. And
One of the things we did a pre-conference workshop yesterday, and the level of expertise in the room really changed what we did, so it almost turned it more into a seminar. So I think that is the format that I think will work well here too. So we want to generate some real conversation about all the pluses and the minuses and what other choices could have been made and so on and so forth.
Okay.
So we're talking about a family that consists of a mom, a dad, a son, at 4 years old at the time of the separation. They met in 2007 in Brooklyn, New York. Dad was a pre-med student, and mom was employed as an insurance adjuster. In 2008, they have a son that's born, and the father begins to notice that mom becomes extremely critical and blaming toward him. And we think this is one of the key points to say, hey, wait a minute, let's put this in a notebook somewhere, and we're going to be thinking about, is that going to be carried out through this relationship? Is this a potential personality issue that's going on, or is it just dad's random observation or allegation? So we're just going to store that information and see how that may unfold later on. The idea that she's becoming more critical and more blaming. Were you going to say something? Okay, in 2009, the parents get married. So they have a relationship in 2007, have a child in 2008, and they get married in 2009. We notice that there are different religions and backgrounds, but dad agrees to get married according to mom's religious preferences. Dad is accepted into medical school at Vanderbilt in Tennessee. Dad moves to Nashville, and the conflict increases. One of the points we wanted to raise is the idea that we're talking now about a multicultural family. Not only is it multicultural, but then there's an interesting intersection of religions. That's potentially a problem. Okay, and one of the things for mental health professionals is one to know a little bit about the cultures. If you're going to get involved with this family, how familiar are you with the cultures? How familiar are you with the differences between the couple? And also looking at how this is going to perhaps exacerbate the conflict between the parents and the family.
We also just heard in the prior presentation from Catherine McWillie that parents coming from different countries and backgrounds really does increase the chances of intimate partner violence, abduction, things such as that. And I remember the other point I was going to make about the comment about the parent, his criticism of the mother being controlling. The reason I think that's significant is because we have a sense, we know now the role of personality disorders in these things. So I think it's good. I think it's good. Oh, there you go. I think it's good to be aware of that and sort of monitor that. That's not to say that we have a bias that we assume somebody's controlling. They must be, but rather to really pay attention to that.
And my comment about, hey, let's pay attention to the fact that mom now is becoming more critical of the father. We have to be careful as a mental health professional. We talked about yesterday is the whole area of biases. And so we don't want to set the stage for, oh, I got it now. She's the critical one and she's the problem, and we're only at the very day one of the case. Right. So we need to be kind of self-monitoring our own thought processes and biases. Yes?
Father notices that mom becomes extremely critical. Is that father's statement?
Yes, that's dad's observation of mom.
What's mother's statement? Did she say something about the situation?
Well, we don't know if he confronted her with it, but he's now, we're saying that
We have the story, his story.
that's it. So that's an issue, yes.
The other thing that I notice in this piece of our story is just whenever I get to know families, and there is one member of the marital couple is from another culture, that sometimes the expectation of what divorce is like is based on their experience of divorce from their home country, which can be very different from what divorce is like in the United States. So sometimes the expectations can be somewhat unrealistic if they're based on the partner's home country experience in divorce, and that's something to manage as you're working with the family, are those cultural differences in how divorce is handled from country to country.
Another issue sometimes is you'll get a family, they both were from a country, they both moved to America, and one gets Americanized and the other one is still holding on to their traditions much more and is really struggling with that. So I've encountered that quite a bit as well.
Ready to go to the next
it's my
segment?
turn. Okay.
Yeah.
So here's the next segment. We're now in January of 2012. The conflict is now increased between the parents. There's more tension. You know, has he been accepted in medical school yet? I don't recall.
Yes, they're in
Yeah, okay.
Nashville.
So he's now, and the stress of that, can't find a job. There's economic stress, and plus whatever interpersonal conflict, which appears to be on the rise. So on the temporary orders that the court issued, it gave a 50-50 because there was no reason really kind of not to. However, then there was a abuse allegation to the son executed by the father allegedly. But the reporter was anonymous, and we know about how these things can be. We have to take that seriously, certainly, but there's a temporary restraining order that is issued out of, as we have all heard many times, out of an abundance of caution, will be done, and whatever the follow-up evidentiary hearing hadn't happened, but those often get delayed, so the temporary orders often stay in place, which is a real problem. The next comment on here is it was a consideration of having supervised visitation, and the allegation being that it's necessary to protect the child because of the alleged abuse by the father, which was not substantiated at all. So the attorney's decision in collaboration, I'm sure, with the client, to basically say, no, we're not going to do that, because the downside of that, of course, is that it tends to have the potential to label that person as having been committed some violent act. So on the other side of the coin is, and I've heard this many times, if the only time a parent sees the child is in a supervised setting once a week, and it typically is less than that, then they will advocate often to continue seeing them. However, that also can have an accelerant effect on alienation. So those are some of the things that I think we see all the time. I mean, I've heard of attorneys suggesting that someone was accused of being violent, and the attorney would say, well, why don't you take a batterer's course to make that go away. And of course, that does not make it go away. In these cases, it makes it worse and becomes more of a selling point for the alienating parent. So anyway, there's, as a consequence of all this mess, there's 5 months of no contact at all between the child and the father. Of significant here now is the mother then, we later learn, through discovery, I believe, that the mother has been shopping for therapists and has taken contacted about a half dozen of them. And only 2 requested or insisted that they'd speak with both parents before they see the child. The other 4, that didn't bother them. Yes?
Is that allowed?
Boy, that's a great question. It's done state by state, so the laws are different. And you would think there would be a red line guide, but I'm not. In the state of Florida, there's not. So it's a lot more problematic than you would think. Yeah.
I would argue I'm a psychologist, so I go by APA guidelines, but they say you need to do a full assessment of the child. Well, you're not doing a full assessment if you only have 50% of the child's information. So I would argue that should not be allowed ethically, but people do get away with it. Yes. Oh.
It is not allowed.
Hold on. Amy, one of the reasons that Robert Gardner, the editor of that Schlock Journal, has license revoked by the California Board of Psychology was that he did a so-called emergency assessment of a child in this situation with somebody that he supervised and never contacted the other parent. Made all kinds of recommendations, interventions, never contacted the other parent. Revocation.
Yeah, it should not be a thing. Now, I will say, as a psychologist, I've had situations where I can't get hold of a parent, but I have it very well documented that I am trying. So, because I don't want to deny a child services because a parent's going, who knows where. But
Well, and sometimes we get orders where the parents have independent rights, so they can each take the child to a doctor or each take the child to a therapist. And so sometimes in Texas, if the court order says there's independent rights, the therapist doesn't feel obligated. However, if you look at our guidelines for best practices, that's not supported. Of course, we should all talk to both parents, but this continues to be a mistake on the part of practicing mental health professionals to not get the narrative of the history, what's going on with the child from each parent.
But
I think if you watch what's going on, and mom's going to see half a dozen therapists, 2 of which they contact the other parent, you can bet that those 2 are not going to be around in the case very long because moms were going around and she's shopping for therapists, obviously, okay? And she wants the right answer. The right answer is her opinion. And so somebody going to contact both parents, that means they really want to do a good job, and mom's not real interested in doing a good job.
Well, and I think one of the other issues here is what we heard earlier about multiple interviews of the child. So at this point, the child's been interviewed by CPS and at least 5 different therapists. And so that's an issue in terms of the memory and the narrative and how that morphs after each telling of the story.
and this kid's only 4.
How did you learn that she went to the other 5 therapists?
Discovery, Mike said.
They kept the record.
Yeah, exactly.
Okay, we're going to move.
One final thing, Dr. Lorando's comment. I think one of the problems is, I think something like that, someone took action, but it's really difficult. I mean, it takes a lot of resources and a lot, emotional, financial, whatever. So that's one of our problems. Is there has to be this whole third-party investigation done, which is laborious and expensive, and not many people can do.
That makes another issue, Dr.
All right, go ahead.
You and I, all 4 of you guys, and me, are obligated to say something about a psychologist that acts this way.
Yeah.
If we don't,
Yes.
it's on us.
Yes.
Yeah.
Yes.
Very good
Absolutely.
reminder. Thank you, Dr. Lorandos.
Okay, Amy, the next phase of our story. Oh, you didn't finish
No,
mine?
I think I did.
Oh, I thought you did.
I'm clearly finished, yeah.
Okay. Well, he mentioned they unsubstantiated the abuse findings in April. It takes them, of course, a month and a half to go back to court. So, and mom during this time is denying access. But when they get back to court, the judge does drop the restraining order, and he appoints a guardian ad litem. In this case, the guardian ad litem as a senior attorney, which, I mean, nothing against attorneys, but a lot of attorneys do not have a mental health background and an understanding of alienation, and they just take the kid's voice at face value, from my experience. Now, I know that's not true with everybody.
Outside of Dr. Lorando's.
Yes,
Right,
outside
right.
of him. Well, there's some others, too. I would argue there's some others.
Right.
Did you have something? No. Oh, okay. You just like it. And during this doctor shopping, she manages to find a therapist who's going to back her claim. And so she files a motion for a reconsideration with the therapist support. And that's a huge problem. I don't know about all the states, but I know in Texas we are not allowed to make any recommendations about possession and access for children whatsoever unless we do a full custody evaluation. Clearly, this therapist has not done that. And you certainly are not allowed as a therapist to say, hey, disobey a court order. Like, that's ridiculous that any therapist thinks that they can do that. So she files this motion for reconsideration. The father rightly files a licensing complaint against the therapist. Good for him. Saying you can't be making these recommendations. Mom's motion is denied, and during this time, during the motion for reconsideration, he should be having access to the child, but mom is still denying him access because that's what they do. And so what he does is he then files for contempt because there are violations in the parenting plan. And the family therapist is appointed to help the family because of all this.
If I could just make one comment about the senior attorney. There's a book that maybe someday I'll finish writing, but maybe not. But there's a term in there that I call the senior partner syndrome, which is the guy that's been practicing 40 years, oh, I know all about this, and they're not really open to input about this, and their understanding of parental alienation might be pretty primitive. So as a consequence, sometimes these kinds of attorneys that you would think would be the most seasoned might also be the most problematic.
Yeah. And now Dad has his first, third, and fifth weekend. If you remember at the beginning of this, he had 50-50. All Mom had to do was stir up all this stuff with false allegations of physical abuse, and now he's reduced his parenting time.
Yeah, so one thing that stands out in this section to me are the multiple therapists that are working all on their own with really no coordination, right? There's family therapist, Dad's found himself an individual therapist, Mom's got into individual therapy, but there's no talking going on. There's no coordination of care so they're all kind of working in their own limited scope without information from the other therapist.
If I could make another little jump in here real quick, Kelly, what you and Amy have put together in using in Texas, if you could take 2 minutes to just describe that, I think that's really important. It might be helpful.
It solves that problem.
Yeah.
Okay, so what we've been doing over the last several years, actually, is working with a sort of a team lead. In Texas, that usually means one of us has been appointed as the guardian. And so the other one is asked to be a family therapist, or we find another person that we know who has skills in family therapy and understands PA and understands high conflict and all of those things. So just a random therapist is not chosen. And if somebody needs individual therapy, then that therapist is also chosen by the team lead. Then it becomes the team coordinator's responsibility to make sure everybody's talking to each other. So that probably means monthly team meetings between the therapists to make sure there's a coordination of care and alignment of treatment goals. And that those treatment goals are that the child can have as the best relationship possible with both their parents. and be kept out of the middle of all the conflict. That person also is the person who reports to the lawyers and to the court. So in a way, that buffers the therapeutic relationship. So sometimes what happens is an individual therapist or a family therapist or a parenting coordinator gets called to court. They're asked to testify, and then somebody's mad at them. It kind of ruins their therapeutic relationship. In this model, this allows just an ease of communication between legal professionals in the court and what's going on with the family. And so that's the person who goes to court to testify, not that the others can't be called, but when there are review hearings or when there are written updates given to, which is what I do when I'm in that role, is I usually give a 30-day written update to the lawyers so everybody knows what's going on. And if I think there needs to be a change in the care, then I make that recommendation in those updates.
You know,
so it just streamlines things.
In the late 80s, Richard Gardner basically said that therapy, not that important, it basically restored the relationship. But he said when therapy is involved, it should be one therapist because he was aware of how divisive this whole process can be. So this takes that and kind of fixes it. It allows multiple people, which is indicated, but then also protects the confidentiality and kind of integrity of it.
I will say sometimes you might get a rogue therapist who, that what you say divisive, every once in a while you get one who doesn't get it. You thought they were going to get it, and then they don't get it, and it can cause a lot of issues. So I feel like the bigger your team is, the more at risk your therapeutic approach is for having a problem.
That weak link.
Yeah,
thing,
you have
yes.
one weak link, oh my goodness, it can make a huge problem.
Yesterday, we were talking about the systemic involvement in the system, the issues. You know, we talked about dispositional within the person. We talked about situational in terms of, dissolution of marriage. And then we talked about the system, looking from the Phillips and Bardo's program. Your system, your approach, takes care of that systemic issue to a large extent, giving feedback to the court, and it's a give and take. So there's progress going on, as opposed to what typically happens. They order an evaluation or they order therapy, and then, that's the end of it.
Right. The other thing that comes to me in this particular slide is that the therapist writes the letter saying that the reason that she's requesting this restriction of time or no contact with dad is because of the trauma symptoms that she sees in the child. So child comes into the office and he gets a very kind of hyper, runs around or shuts down, and she interprets that as trauma, which it very well could be. But she equates or she associates the trauma with dad rather than maintaining more of an alternative hypothesis that it could be about the child being caught in the conflict of the relationship, right? So, again, we're working in a very narrow scope, right?
It's very important to keep that open hypothesis at all times, to know, okay, I could be proven wrong, so let me see. Yes.
What does court do when one person sends in a letter only being helpful to one parent and not to both parents?
I've had cases where the judge has actually taken off a therapist who did not talk with both parents because they thought they were biased. I can't say it always happens, but I have seen that happen.
Alternatively, it can go the other way too. And it's amazing to me that judges really don't know the rules very well about what should happen, what shouldn't happen in terms of ethical boundaries and things like that. So they'll sometimes order things that are not ethically valid. So sometimes judges will take a therapist's opinion and run with it and just agree with it because it hadn't been properly presented.
Actually, in this case, the judge did dismiss that individual therapist. That's how the family therapist got appointed. Yeah.
And if you look too, I just remembered, mom is an individual therapy for a PTSD diagnosis. And a lot of these moms will claim that there's something PTSD going on when maybe there was trauma, but it's not what they're saying it is. I had a case a long time ago where mom was in, the same kind of situation. Mom had gone and said she had been raped by her ex-husband, was very much into that. However, I later found out the rape was by a relative from her past. It wasn't her ex-husband, but she was attributing all of that trauma. And so, yes, it looked like she was traumatized, but the therapist didn't realize the reality of the situation.
Okay, and so at this point in our story, Dad's had first, third, and fifth weekend visits for 6 months. The family's been seeing a family therapist. The family therapist has been trying to work on communications between mom and dad to make them more productive. Mom's canceled about a third of her sessions at the last minute, and the guardian has been doing the assessment of the family and has completed it. The attorneys decide, let's go back to court for further temporary orders. Dad's attorney's hoping that he can get the 50-50 reinstated at this point. However, the GAL's recommendations come back without any recommendation for an increase in Dad's time, based on the fact that the GAL believes that Dad is potentially dangerous, may have an anger problem based on Mom's allegations. The judge does not increase Dad's time at all. However, he is disappointed in the GAL's report and finds it to be limited and based on hearsay. And so he appoints another GAL, a psychologist this time, with extensive experience in doing custody evaluations and working with families who are in family court. Shortly after this hearing occurs, Mom increases her participation at school to the point that she is at the school almost every day, volunteering, interacting with teachers and staff members. About 2 months later, another CPS report's made, alleging physical abuse to the child by Dad. It's not clear who made the report, although Dad thinks that it was a school teacher from the way it was written and the fact that he hasn't been able to interact in a relaxed manner with the staff and the teachers at the school. He asked his mom to come stay with him from New York on his weekends so that there's no question that the child is safe when he's with him, and so that he doesn't get put in that position of being stuck without any visitation, what happened last time. Mom influences the school by showing them the CPS paperwork that there's an open investigation on Dad to not allow Dad at the school. So Dad isn't able to pick up the child or drop him off at the school. He has his mom do it for the next couple of months. While CPS gets through the investigation fairly quickly for CPS and rules out the allegations pretty quickly. So what did you guys see in this particular set of facts on our case?
Well, I think the school information is kind of interesting because what's very common, not only do they bring protective orders to school, they being the alienating parent, the favored parent, they'll be willing to share the protective orders. They'll bring motions to the school. They go into the child's cumulative record, and I will tell you from personal experience that when I worked in the school systems, those documents are still sitting there years later. And so the school keeps enforcing an order that has been dismissed or found unfounded, and they're just sitting there, and that parent can't pick the kid up, can't take the kid out to lunch, and it's just it's a continuing problem. Now, Dad's got to get a lawyer to contact the school board lawyer to say he can have permission because the whole thing's been resolved. But you're talking money, you're talking time. Mike?
One of the things I found is I believe there are two places, this is mainly for evaluators, maybe for therapists, two places where you find evidence of alienation in writing, and that is school records and medical records. But as you can see, the school records are going to have probably this temporary order, but not the follow-up one where the order was denied, and we see that all the time. But as a consequence of that, I mean, it's just a phenomenon that's very, very common.
Mm-hmm. Mm-hmm.
I also think this gives a little hope. I worked in the school system as well for a while, and I feel like one place that we could focus some attention on is educating the school administration what alienation looks like. Just like we educated them what sexual abuse could look like, signs of that could look like. We educate on other signs of abuse. then they can actually think, oh, this is a little strange that this mom is always over here talking about dad. Like, what's up with that? Or why is dad always over here talking about mom? That should be a red flag to school personnel, just like other behaviors in children should be a red flag to school personnel. And they do not have that knowledge for the most part. I feel like that would be a huge way that we could get some advocacy going, yes.
Sorry, but isn't it already the responsibility of any principal to use only relevant and current court orders?
Yes.
Only if they're informed,
If they have them, yes.
if they have that information.
Right, and I often tell the target parent the second they get a new order, you go march that over to the school yesterday. Like, just get it over there. Right, but they do have some issues with that in some small town schools. I do know that.
More often than not, what I've seen is the alienated or the rejected parent hit their attorney, will contact the school board attorney, and they usually resolve it right there.
But at whose cost, though?
Yeah.
Oh, yeah, of course. Yeah, of course. I mean, the targeted parent gets so rejected by that system that no matter what they bring in to contradict what's in file, they frequently will just not deal with it. That person's not even supposed to be on campus. They might even call the officer and police officer that's on campus to get this guy off the campus, or the woman off the campus. So you're getting another system involved in a case that really shouldn't be involved. The school counselors get involved because then the child is going to the school counselor. How many times does the favored parent encourage the child? Well, go see the school counselor. Now you got a school counselor coming in. Of course, the school counselor just talks to the child, takes the child's word, and runs with it, and then maybe files an abuse complaint with Child Protection Services. And the whole thing just starts snowballing out of control.
So the other thing that we see here, if you're looking at the history of the case, is a pattern that's beginning to evolve where there's a court hearing, there's some sort of decision that mom's not quite happy with, and so shortly after that, this is the second time in our history that there's been an abuse complaint filed. So, I mean, that becomes important when you're doing an evaluation to look for those patterns.
Can you hold on just a second till you get a mic? Yeah, thank you.
Is there anything that parents, like the parent that's doing the alienating, they're costing the alienated parents hundreds of thousands of dollars in court fees, and they file in court and it doesn't get heard for like a year or 8 months later, so they're still in there. What can the alienated parent do to recoup those costs? Or if it's all said and done that this person is doing the alienating, how are they held accountable?
Johnny Depp.
Johnny Depp. I know. Well, we don't have that kind of money. No, I'm just kidding.
Well, there are cases where a judge will order some reimbursement of legal fees. I recently had a case where it was clear from the report that I wrote that there had been a huge amount of work done on the concerns of one parent, and all of those concerns had no support whatsoever, but the work had to be done, right, to investigate them all. And the judge did take the time to read the complete report and then awarded some attorney's fees to the parent who had come up with all of those complaints and allegations that didn't end up having any support.
In the past month, there's a case in Vancouver, Canada, where the target parent's lawyer successfully put a motion in court for special cost award and was granted it. And that judgment was just released, and it was precedent-setting.
One more little, I should have said earlier, when there was a restraining order that's been temporarily and then taken away, ordered and taken away, there's an opportunity there to begin to expose the alienating parent. And oftentimes that is not taken advantage of. Just to take the first bite of the apple and get the light shining more in that direction, because otherwise it just doesn't happen. So you really have to force that kind of thing. So begin to make allegations about here we go again. And if we can get the audience, the trier of fact, to go, oh, here they go again, then you've made progress. But I think there's opportunities in these false allegations that are not often properly executed.
But don't we see that dynamic so often, Mike, where the focus is so intense on disproving the allegations that you spend all your money, all your time, all your effort on proving that what somebody said is false, and that the accuser gets completely forgotten, right? And we see that in working with alienating or alienation in the therapy room, where the targeted parent and the child are having all the therapy, and the alienating parent is not having any whatsoever. So I think that, yeah.
I was going to say, at least in Colorado, and I don't know about other states, we have a statutory provision in the Uniform Dissolution of Marriage Act that where if you're bringing a motion concerning violations of parenting plans, which would include, which applies to refuse and reject cases where a kid or kids are refusing to go to the other parents for parenting time, that if the court finds that there were violations of the plan, and a parent the targeted parent obviously missed parenting time, it's non-discretionary. The court shall award reasonable attorney fees. And also in Colorado, I think it was in like the summer of 2018 or 2020, case came down that said that parents have to make efforts. It's their responsibility to get the kid to the other parent. And they can't, it's kind of the analogy of what would you say if your kid said they're not going to go to school? You're not going to, so the court's not going to tell you what to do, but you'll ask questions like, well, did you impose consequences? Did you withhold electronics? That kinds of thing. So those two mechanisms together, at least here in Colorado, get to that issue of attorney fees.
Okay. All right. Bob?
Here we go. June 2013. June 2013, the divorce is finalized. The Guardian wrote a report. It revealed mom's alienating behaviors, limiting time, inciting anger and fear in the child relative to the father. The time sharing was 50-50, was reinstated. Reunification/family therapy was ordered. Recent marriage and family graduate from a local university, that was Dad. And in July, Dad graduates from medical school. Dad decides to move back to Brooklyn to practice his medicine for financial reasons. The reunification therapy is going poorly. Therapist minimizes mom's alienating behavior. Dad's therapist encourages Dad to move, and he believes that the distance might decrease the conflict between the parents. And then Dad's therapist was not familiar with alienation.
I mean, one of the themes that we see over and over, and really this whole meeting, all these meetings, has to do with education. I mean, getting people on board that understand this. That's really covers every one of these issues. And that's really what this is about, but it's so frustrating. I don't have to tell you all that. So.
Well, yeah, and I think this speaks to especially the recent graduate student, is that graduate students aren't getting this information in grad school. In the family panel, I think one of the participants on the panel was talking about how she had had lots of classes in psychology and never once has alienation been a subject that was talked about. And, you know, I spent 12 years in grad school, God forbid, but but, you know, I can think of one marriage and family class that had one segment, maybe 1 week of the class on dynamics of divorce. Never talked about alienation, but even talking about what other dynamics you might see in a divorced family, those things are not discussed in graduate school. We have to get that education outside.
We need to get that to undergrads. I teach alienation to my undergrads, and I can't, every time I teach it, some of them tell me, oh gosh, I think I've been alienated every single semester.
Astounding.
So Dad's therapist has been a great support to him through this process, but and certainly understand the exhaustion in a targeted parent and the need to move on, especially after med school, and you've completed that and you want to get a fresh start and the divorce is finally over. But there have already been signs of alienation in this case, and so for Dad to make the decision to move when he's now got a 50-50 schedule and final orders, and he's going to move to New York and have to have a long-distance schedule. If the therapist had known a little bit more about alienation, maybe he would have talked to him more about the pros and cons of that, like what are the risks of that. Yeah, it would be great if the distance gives you less conflict, but it could also increase your son's resistance to you that at this point you're just kind of seeing during transitions, right? So, Mike?
Yeah, just well, we're very low on time, but basically there's a continuation of the sort of error of decision about moving, in my view, that he's underestimating the role, the power of alienation, which again, back to the education part of this. So now Dad begins a serious relationship, as does Mom, and we know that's a trigger. So that exactly begins to happen. And now this child, who's, I think 5 years old by this time, now is beginning to show different signs of stress, being upset and untalkative. The transition phenomenon, even though he's only 5, that's unusual, but it passes pretty quickly. So Dad then finally, as you see, starts therapy with someone that understands this stuff. And we don't know what actually happens, but maybe we'll leave that to discuss about what should happen. I mean, what should happen with this father who's now in Brooklyn? And so it's a very dicey, problematic decision process.
Well, so Mom decided to move back to Brooklyn also, and then they both start serious relationships, and the son starts increasing his resistance to Dad. Dad does start therapy, and that helps a little bit. And then our last segment is that Mom started dating somebody from Nashville before she moved to Brooklyn. They decided to move together, and then once Dad gets married, she's asked to move back to Nashville. Dad agrees to avoid conflict, and so once they get back to Nashville, then the son's alienating behaviors or characteristics even increase, and so Dad's left with the decision of what to do at this point.
So that's one of the
Should he go back? Should he go back or not, based on his experience before? And so it's a dilemma that parents have about whether or not to just let it go and hope it gets better, or to restart litigation all over again.
And it's interesting that the specifics of this case are not uncommon. I mean, there are variations on the theme, but they get crazier. Some of them are less crazy. I mean, we're talking about what people do, and we talked yesterday a little bit. How do good people do bad things? How do people alienate their own child against another parent? Which kind of defies logic and reasoning. We are done.
It is.